Welcome to On Subrogation, the litigation video series about how to recover your damages from the people who caused them. I am here today with Lee Mendelson of Mendelson Schwarz out of Los Angeles, California. Welcome, Lee.
Thank you so much for having me. I really appreciate it.
It's great to have you. You are going to talk to us today about workers' comp in subrogation.
That's correct. And I'll tell you, it's interesting because usually when people talk about subrogation, the first thought is not workers' comp.
No.
It's kind of an interesting story, and I love to tell this, and my partner, Mark Schwartz, always gets a kick out of it, and he'll laugh as soon as he sees this. But I started my law practice on a laptop in a Starbucks, and when
you could have been a writer. You were so close.
I'm so eloquent, right? And so when I did that, my first files that I had were collection files, and I managed a collection practice. And as we grew, I started taking on uninsured auto cases because it's very close to collections in a lot of ways. And as my practice grew, I became more and more involved in subrogation. Our subrogation practice expanded, and I went into other directions, and that's how I ended up handling quite a bit of workers' comp subrogation throughout California.
Wow. So tell me, because workers' comp subrogation is different from state to state, but let's talk about it in California because I know you have a lot of experience with it there.
Right.
So tell me about some of the challenges that you face when you're dealing with subrogating work comp in California.
Well, I mean, the first challenge, and this is always the largest challenge in workers' comp subrogation, is balancing the different parties. There's a lot of different moving parts in workers' comp. It's not just plaintiff versus defendant or plaintiff with several defendants or that kind of a situation. You're dealing with a PI lawyer generally, personal injury attorney. You're dealing with a defense attorney, and you're dealing with, depending on how many people are injured, several different parties. You're dealing with the employer, and you're dealing with the injured worker. The most important thing to remember about workers' comp subrogation is who is your insured? That's the question that you ask. And the way I always tell people to remember that, the person that's the insured is the person that's paying the premium. The insured is the employer. So the injured worker is represented by a personal injury attorney. Generally, they'll file suit and against the defendant, whoever the third party is that caused the damages. And what we'll do later on, there's a workers' comp claim going on. He'll also, the injured worker will not only sue the third party, he'll also file a workers' comp claim in the administrative courts, right, in the workers' comp court.
Right.
And as our damages, as my client, my carrier's damages accrue, and they continue to pay workers' comp out, which is no fault. Obviously, it's no fault. If you're hurt on the job, you get paid. It doesn't matter who's at fault, they get paid. And as we pay that out, our money goes up, our balance goes up, our indemnity might go up, and we take that balance and we go and intervene generally into the personal injury case and sue the third party as well.
Okay, so the format that you're using in California for a lot of these is an intervention into the personal injury case to assert the work comp lien at that point?
Correct. And it's not always, I mean, there are times where we file our suit first before the injured worker files a third party suit, files a suit against the third party. And when that happens, we file our suit, and then generally the injured worker will file their personal. They never intervene in our cases. They'll file their own case, and then we move to consolidate.
Right.
But we want to keep it with them. We want to keep it with the personal injury case because there's a lot of legwork that the personal injury attorney will do. Not that we just ride the coattails. We have to do a lot of work too, but there's a lot of expenses involved in these massive personal injury cases, and our insurance carriers would rather somebody else spend the money, and we write.
Well,
and
they're already doing it,
and they're already going to do it.
They're already doing it, and it makes more sense to have a seat at the table in their action, I would imagine, rather than trying to come along afterwards and sort of pick up whatever's left.
Well, and you have to watch the ball, and that's why it's so important to intervene. I think, especially in California, there's other states. I mean, California's lien rights are okay. There's other states that are have very strong lien rights, where you may not have to intervene in the case. But I always recommend intervening in the case, having a seat at the table, and then when they decide to, and that's why firms like Rathbone, firms like ours, are so important for this type of situation, because we don't want them to settle around us. We don't want our workers' comp, we don't want the PI attorney to settle, everybody sign a release and try to knock us out of the ball game.
Right.
So we want to make sure that we say, hey, we're here. And not only do we say we're here, we are actively involved in the case.
That's
and we
right.
want to participate in the case to make sure that our rights are covered and that we get the maximum, the reimbursement that's coming back to our carrier is the highest number we can get.
Absolutely. Because at the end of the day, that money has been paid.
Right.
And to not repay it would be a double recovery for the injured person.
Oh, I spend so much of my time talking to personal injury attorneys, explaining to them, hey, I know that there's the policy limit is $200,000. I get it. And I know you did a certain amount of work and you want to get paid your fee. I get it. I want to be paid my fee too. But and I want money to go to the injured worker. I'm not saying that injured worker doesn't deserve money, but we have a $37,000 lien or a $50,000 lien. That injured worker's already been paid $50,000 by our carrier. They've already got that money. Now, I'm not saying that, when we settle this case that we don't want to, work something out with you. But at the end of the day, we need a seat at the table and we need to make sure we get our full reimbursement, or it's not the full reimbursement a lot of times, but as much of the reimbursement as we can get.
That's right. Well, because it's about protecting your client's rights too.
Right, exactly. And so that's why I feel like the intervention is the way to go. And then what generally happens, there's discovery back and forth like anything else. In these particular cases, go to mediation.
Yes.
They mediate. And that's how we usually work these out.
Well, that's great because then everybody can reach a resolution that they may not be super happy about, but it saves everybody in the long run.
Right. And I get phone calls telling me, oh, we already settled the case for $1 million. I've gotten that, and I'm like, you didn't settle the case.
No.
Because to the defense attorney, you didn't settle the case because we're not a part of the settlement and we have an intervention claim that's still pending.
Right.
We don't want to go to trial on our intervention claim when you've already settled it. That's not my intention if I don't have to. But if we have to, we can do it.
Right.
So, just make it out. Just let them know, hey, we're here. Don't forget about us, and we're working it. So
Absolutely.
That's the name of the game.
Well, and that sounds like the most effective way to handle it.
Right. So, I don't know. So we've been really happy with it. We've been really happy with the workers' comp work that we've been handling over the past many years. And, so that's it. Yeah.
Well, Lee Mendelson, thank you so much for being with us here today. I'm Rebecca Wright from Rathbone Group, and that's the long and short of it.